have to move the whole screen to do that. Is that better? Okay.
Joe, if you're talking to us, we can't hear you. Apparently not.
I think he's talking to somebody else.
Yep. And Judge Huskin and Kim, I don't know if you saw the email, but I was reviewing the minutes this morning and noticed that the judge, you and I hadn't discussed the suggestion by Judge Robb in terms of the.
Wait till I officially start the meeting.
Yeah. No, I was just pointing out that I sent an email for you guys to look at if you didn't see it.
I didn't.
Okay. There were a couple suggestions for language that we'll want to discuss.
Madam Chair, I'm here. I'm simply stepping away to get some caffeine.
Oh, deal. Not a bad idea. I'm just going to wait another minute here with the new platform for today. I want to make sure everybody who wants to get in is able to get in. Joy, at the moment, I only see 4 videos of people. I can't tell if it's because others have their videos turned off or I'm not seeing them on my screen.
Okay, because I see most of the members have their cameras on.
Sometimes you can't see people on camera if you're having bandwidth issues. I find if you click on the little 3 dots at the top and then do together mode, where it's all like you're sitting in a movie theater, I can see more people than if I have it in the gallery mode. So you might want to try that, but it's funny to see us all sitting together.
Oh, that's funny. I hadn't seen that before.
Big white cushy chairs. Okay.
Yeah, Joe, it looks like you're sitting on the army chair. There you go.
That is funny.
That looks like I'm sitting on the arm of my chair.
Yeah,
it
in this
does.
together mode thing. Yeah, I'm going back.
I was going to suggest the large gallery, but that doesn't put everybody on. You only see well, I see 9 of us at the same time in the large gallery mode.
Oh, that's better. Yeah. The chairs are a little weird. Okay. All right. I think. Joy, are you ready for us if I start the meeting?
Yes, ma'am.
Okay. All right, then I'm going to go ahead and call our notice of public meeting for the Child Support Guidelines Committee, November 19th, 2021. It is now 9:04 a.m. Meeting was noticed for 9 o'clock. And I will go ahead and take roll. Do we have Kathleen Baker?
Here.
Ms. Shapwell?
Here.
Ms. Cliff?
So Karen Cliff has asked me to be present today as her designee. My name is Adam Hughes, and I'm a deputy DA with the Clark County DA's office.
Thank you, Mr. Hughes. Assemblywoman Cohen,
Here.
Ms. Crecilius,
Here.
Mr. Freeman. Can we see him? I don't. I see his name off to the side. I do not see him.
I don't show him in the meeting yet.
Okay. Assemblywoman Hardy. Senator Harris. Judge Hoskin.
I am here.
Senator Pickard.
I am here.
Judge Robb.
Present.
Mr. Sanford.
I'm here.
Judge Shirley. And Justice Stiglitz. Okay, let the record reflect that 10 of our members are present and that we have a quorum. And we will move on to the next agenda item, which is public comment. For those who would like to give public comment, it is limited to 2 minutes per person. And I will unfortunately hold you to that. The good news is our agenda is now set up for public comment for individual items on the agenda. So is there anybody that would like to give public comment? Joy, I'll let you start that process.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. Again, to give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue.
Chair Surratt, this is Margot Chappell. It appears I may be the only one requesting the opportunity to talk during public comment.
Okay.
I wanted to, on item number 10, where we've got some of the changes that I believe Senator Pickard and Judge Hoskin were working on. There were some issues that Clark County had, and the program would like to look further into it before we make any decisions on it. So I'd leave it to your discretion whether we talk about it today or postpone it to the next meeting.
Okay, and for clarification for the record, you said item number 10, that is regarding the joint physical custody language?
Correct.
Okay. All right, any further public comment?
I'm showing no other hands raised.
All right, thank you, Joy, I appreciate that. All right, let's move on to the next agenda item, which is approval of the meeting minutes from October 15th, 2021. Would anybody like to make a motion?
I'll move to approve.
Okay, Senator Pickard is making a motion to approve. Do I have a second?
I'll second.
Ms. Baker is our second.
I need to abstain. I wasn't at that meeting.
Okay. All in favor, state aye.
Aye.
Opposed?
Aye.
And then we had one abstain. Motion passes. All right, our next agenda item for
Ms. Surratt, I was
Yeah.
just going to tell you, just so that everyone is aware, I believe we just received an email that Mr. Freeman is attempting to enter the meeting and is having difficulty. I think we can proceed. I just wanted everyone to be aware that we are having.
I think he just joined.
All right, let's see if we get him on here. Mr. Freeman, are you there? Oh, you are. I see you.
Yeah, I'm on my phone. It's not working on my computer, so.
Okay. I have you marked as present.
And this is Margot Chappell. For the record, I just changed your status in the meeting, so hopefully you might be able to get in.
Yeah, my camera's off for some reason. It says it's not in there.
There, we can see you now.
Ah, there you are.
Okay. All right. Now, for a little bit of business, so we know how we're going to proceed through this agenda. We have several items that were held over specifically for the intent of our public comment last time from the American Academy of Matrimonial Lawyers that the Nevada section was going to provide us with some possible edits. I did not receive anything, so we may be skipping through a few of these items to be held over and then removed from the agenda unless we get input to proceed on them. So the first item we've got is agenda item number 4, which was the reorganization of the statutes and cleaning up of the language. That was one of the ones specifically that was going to come from AAML. I don't know. We also opened up for them to provide it to either myself, Judge Hoskin, or Senator Pickard. Did either of you receive anything from them?
I did not, and I'll touch on it when we get to the items that I was responsible for that Senator Pickard started talking about at that point.
Okay.
And I did not either.
Okay, thank you. Does anybody want to speak on that agenda item? Hearing nothing from the committee right now, do we have anybody that would like to give public comment on agenda item number 4?
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you. All right, then we will move on to agenda item number 5, which is regarding the vote that we had last meeting on self-employed income and adding that definition. I'm going to share I'm going to attempt to share my screen. And probably seeing yourselves. There we go. All right. So the reason that we held this over on the agenda was merely to determine exactly where it was going to go into NAC 425.025, subsection 1. At the moment, I put it as in close to the end and then redid the last one as O, because O is all other income of a party regardless of whether such income is taxable. And the other issue for this committee to discuss is just the formality of how to do this. The actual language of after deduction of, when it starts right here with after deduction of all legitimate business expenses, came from our old statutes, was the exact language we voted on, but there needed to be some kind of lead into that about the word self-employed income, and that is calculated after is the wording I came up with. Does anybody have any comments on this or discussion from the committee on this? Can you see it first off?
Yes, we can see it.
Okay.
And I just want to provide a little bit of background. This came up in a case of mine not too long ago where I had a judge, it's one of the new judges, so Judge Hoskin, obviously you're off the hook. But it had, the judge was taking the business deductions wholesale. And didn't recognize, at least until we pointed it out, that this was a sole practitioner who did not have employees, didn't actually have a physical office space, and they were deducting their car, their house payments, their coffee machine, their vacuum cleaner, things that they had purchased for their home because the IRS allows them to take those deductions. And we pointed out these were personal expenses, and the intent of the legislation originally was to make sure that we included income but we weren't including the personal expenses. And when it was pointed out that that didn't actually reflect that way in the NAC, I thought it was pretty important to make that clear.
Okay, and we did vote for it. We did approve it. But what I said I needed to do was figure out how it was going to look within the statute. So
Right.
we discussed me creating a master document, which I took all of the NACs, put them in a Word document. So as we make changes this round, we can track them.
Right. I just wanted to give the background for those who weren't in the last meeting.
Any comment on where I put it or how I worded it with self-employed income that is calculated after? Because that is different language, that calculated after, well, the after deduction is starting at the word after is from the old statute. I had to put some lead-in language right here. Any comments?
Yeah, no, I like it. I think it captures exactly what we were trying to address.
Okay. Any other comments from the committee? Okay, do we have a motion to approve placement within subsection N of NAC 425.025 subsection 1 with the additional language of self-employed income that is calculated being added to our prior vote?
Madam Chair, this is Judge Robb. Move to approve.
Okay,
And I'll second it.
all right. Any further discussion? Hearing none, all in favor state aye.
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 Opposed state nay. Motion, anybody abstain? All right, motion passes. Thank you. So what I'm going to do is I'm going to keep this running document, this running master document of each change that we make that we can submit to DWSS at the end of this process so that we can finish out the public hearing process and it goes to LCB. All right. So
And Kim, if I can make a suggestion, as you go through that, you might add a comment in Word to show where or when the language was voted on and approved.
okay.
That way, if somebody wants to go back to the minutes, they can see when it happened.
Okay, I like that. It would probably be helpful for me too, to be honest, as we track all of this. So let's now do public comment on agenda item number 5.
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
All right, thank you very much. We will move on to agenda item number 6, discussion regarding alimony within the administrative code. Again, this was another item that we had been informed we would receive some additional input from AAML. We did not receive anything. Is there anything from the committee that would like to discuss on this item right now? Hearing none, we'll move to public comment on agenda item number 6.
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you. We'll move on to agenda item number 7, discussion and recommendations on whether income from bonuses should be included in gross income and how the receipt of a bonus impacts child support, and in particular, the language in NAC 425.025. This agenda item was requested by Senator Pickard. Would you like to proceed with this?
Yes, and just by way of background again, what happened was we had a judge here who had experience in the child support court. suggests that bonuses are a discussion for alimony, not for child support. And that was new to me. I went back into the statute or into the regulation and realized we didn't address bonuses in the definition of income. We need probably to address that because bonuses are obviously income. And if they're getting them, I recognize that, the question of whether or not that bonus is a regular receipt or whether it's a one-time, those are things that need to be considered. But in this case, it was part of the compensation package. And it was excluded, even though it had not yet been received. It had been excluded despite the fact that it was an entitlement under the compensation package. And so it skewed in a pretty significant way what that total compensation was. So I don't have solid language yet. I'm ready to propose something, but I thought we should probably talk about it and try to figure out what the boundaries are, what the shape of that language needs to be before we start proposing anything. But I think we do need to make sure that the courts understand that bonuses are to be used in the calculation of gross income.
Any comments from the committee?
This is Adam Hughes. I'm looking at NAC 425.025 as it's been written. It defines gross income, and although it doesn't specifically identify bonuses to be included in gross income, there is a catch-all that's subsection 1N, and it says, except as otherwise provided in subsection 2, all other income of a party, regardless of whether such income is taxable. And in subsection 2, that's the part where the income is excluded from gross income, and it does not identify bonuses. So I think bonuses could be captured in that catch-all.
Well, that was certainly how I argued it, but this judge said, no, it's not part of the calculation. And because it's not, showing up regularly in the paycheck, that will be a discussion as it relates to alimony, but it's not included in gross income. And I found that surprising. I've never had a judge not include bonuses as part of the income when it's part of the compensation package. So that's why I proposed this.
Additional comments from the committee?
This is Judge Hoskin. I'm a little shocked at the story that Senator Pickard. I have no doubt that he's telling the truth, but bonuses are income. I don't know how we got to a point where we would not consider bonuses regularly received. I remember we talked about this in the original committee. I guess my only fear is that by trying to clarify for one judge or a handful of judges, that we end up limiting the rest of us from exercising discretion. So I would just suggest that if we're going to make those kinds of changes, that we're really careful with regard to potential unintended consequences of those. Certainly, I don't disagree. Bonuses should be included as income, especially if they're regularly received and we can track them over time.
Right, and let me clarify one part of the story, and that is that the
take turns.
oh, sorry.
Judge Rob was about to speak, and then we'll let you fill in.
Yeah, sorry.
I actually am interested in the clarification, and then I can go, Madam Chair. Thank you so much.
Okay, go ahead, Senator.
All right, it was a new job, and so the first bonus check had not yet been received. And so because it hadn't been received, even though it was clearly in the offer letter, and it was made part of the compensation package, and as I recall, there was some language that made the final amount somewhat in question, but it was 20% of the standard, the regular income. That was going to be the bonus, but because it had not yet actually been received, it wasn't included in the calculation, though it was clearly part of the compensation package. So, I didn't know how to argue it except that it's it is income, and the judge said, no, that'll be discussed as part of alimony. And I've never heard that before. I've never seen bonuses as a discussion of alimony, even though we couldn't nail down the exact amount that would be received because of the equivocation in the offer letter, and it had not yet been received.
Judge Robb?
Yes, thank you, Madam Chair. Bridget Robb for the record. Judge Hoskin, I have a question for you. I too am concerned about the idea of loading up this statute with so many specifics that I think our colleagues may believe that those specifics are the end of the hunt and don't go to the catch-all. But in this particular case, where I think it is something that could be subject to repetition, and I don't see unintended consequences with this change, would you be offended by making the change?
No. I just want to be clear that in my experience, the more we narrow, the more we limit, and then we end up having a problem on the other end. That's my only concern. Certainly, bonuses, I think, should be a given. Since it hasn't been a given, maybe it does need to be included. I think Mr. Hughes is correct. I think that's the proper place to put it so that we don't end up skewing the rest of the analysis. But I'm not opposed to it. I'm just afraid that as we go down this road, it becomes a slippery slope that we don't want to go down.
And one more comment, Madam Chair, Bridget Robb again. It seems, Judge Hoskin, that this may be something that we just need to make sure that our colleagues and their CLE are catching this and they understand how the statute should be applied or the NAC should be applied.
Yeah, and I don't disagree.
Yeah. This is a constant discussion within the legislature where it is, and lobbying, where I have to constantly tell people I can't legislate against bad judging, inability to read the statutes as is. I can't tell them do your job and read it and understand it, within the statute. So it gets hard to enumerate everything. That's the reason for that catch-all. That catch-all is not new. It's not something we created as a committee. It's something we've had before, where we encapsulate all other income. But Senator Pickard, if you want to propose, and it sounds like there's a desire within the committee, I haven't heard from everybody else, but to go ahead and propose how that language would look and where it might be placed, and on the next agenda we can contemplate it and decide if we really want to go that far or not.
All right, I appreciate that. I actually, the reason I hesitated at the beginning and didn't put forth any proposed language, because I share Judge Hoskin's concern and Judge Robb's concern. I don't want to legislate because of one specific incident. But where this was so glaring to me, and the discussion from the court was so novel to me personally, I thought that it was worth at least discussing. And basically, all I was thinking was inserting language similar to what we've discussed, and that is just saying, bonuses regularly received. And maybe we clarify that further to satisfy the incident where, what if we don't know what that number is, and so maybe regularly received and identifiable or something. Anyway, I didn't know if we wanted to even pursue this, so I didn't want to put the time into trying to craft that language, but it sounds like we are interested at least in discussing language, so I'll do that for the next meeting.
And Senator Pickard, this is Joe Sanford. I would just note that our current definition under 425.025A has a very similar piece already for overtime that I think this could fit very well and without changing the statute or the NAC hardly at all. Right now it has overtime pay if such pay is substantial, consistent, and can be accurately determined. And I think that if we just lump overtime and bonuses, we might be able to very minimally change our piece, but I think it covers the same general issues, and I think has the same general principles. If it's substantial, consistent, and can be accurately determined, I think bonuses absolutely. I've never seen them not be included, but if that is an issue, I think we should do it.
And Joe, I think you make a great point. In fact, when I first started looking at this, that's what I looked at. And my mind put bonuses and overtime together. And so I was actually surprised when I didn't see them in that same sentence. I know in working with LCB, they like to separate discrete concepts. Our Assemblywoman Cohen will probably second that. They like to see any discrete concepts separated in language. They don't like to lump them together. And so I started with that in my mind, and then I actually, in my proposal, put it right underneath that, bonuses, and used the same language.
Additional committee comments?
I prefer that language. I think because we can have situations where there's a substantial bonus that's not a regular bonus. And I want to make sure we're capturing that. Because, we've had, I think all had cases where we had clients who had bonuses that were tens of thousands of dollars. And certainly that should be part of the equation.
I agree.
And we've had clients who got $100 bonus one time, but that $100 could skew their child support so significantly for them that it's problematic for them, right? And they never got it again. So, all right, any further committee comments? Hearing none, we'll move on. So the game plan before we move to public comment is Senator Pickard, you will propose some language next time for the next agenda. And I may even look and just see if a few other states have bonus in their child support structure and just see what they do with it. Just kind of toss it in there.
Sure.
Right. Can we take public comment on agenda item number 7, please?
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you very much. We'll move on to agenda item number 8, which was regarding whether without good cause need to be further defined. This was another one that we were going to receive input from AAML for this meeting. We did not. Are there any comments from the committee at this time on this item? Hearing none, can we take public comment on agenda item number 8, please? Joy, are you there?
I'm sorry.
It's okay. We went really fast through that one. We're probably going to do it on the next one, just so you know. We need public comment on agenda item number 8, please.
Okay. To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you very much. We'll move on to agenda item number 9, which is regarding definition of basic needs of a child. Again, this was one that was going to come from some of that reorganization language from AAML. We did not receive anything. Does anybody want to discuss agenda item number 9 right now? Hearing none, if we could please take public comment on agenda item number 9.
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you. We'll move on to agenda item number 10, which is regarding how we will work with joint physical custody and child support values. We did have public comment in the beginning from the chapel that DWSS would like to hold on this agenda item before any votes, but I do want to point out that we did get a exhibit from Ms. Cliff, as she had noted in our last meeting, that she was going to run some scenarios for us and different income values and what that would look like utilizing the new language that we discussed approving. She did provide that to us. Mr. Hughes, on behalf of Ms. Cliff, were there other comments you wanted to make on this agenda item today?
No, thank you.
Okay. Anybody else would like to discuss this right now, or shall we just wait for DWSS to come to us with their additional input? Okay, hearing none right now, can we please take public comment on agenda item number 10?
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you very much. We will move on to agenda item number 11, discussion and recommendations on proposed language for NAC 425.150 and NAC 425.110 to define public assistance. Ms. Cliff provided us within our exhibits the exact language that she's proposing, and I believe Mr. Hughes has some input on that item from Ms. Cliff.
Yes, just briefly, thank you. And 425.110, this is a section of the code that allows the parties to stipulate to an amount of child support that does not otherwise comply with the guidelines. It provides that to be binding, such a stipulation must be in writing, and then subsection D requires the certification by the obligee that he or she is not currently receiving public assistance and has not applied for public assistance. That's how it's currently written. The proposed change to this section is designed to narrow the type of public assistance to just that temporary assistance for needy families and cash assistance only. Karen Cliff did provide the proposed language at the last meeting, and the committee, and I believe it was Senator Pickard, suggested slight changes for clarity purposes. That was removing a /. That / has been removed, and there were no substantive changes made to 110.
Okay, thank you. And for 150, any additional changes to that?
So 150 again was an attempt to define public assistance better. In subsection D, they did add as defined in NRS 422A065. This was discussed at the last meeting. The 422A065 just defines public assistance to include the broader term, the state supplementary assistance, the TANF, Medicaid, food stamps, low-income housing, energy assistance, and other types.
By just quoting the statute, correct?
That's correct.
Okay. Would anybody like to make a motion to approve these changes as proposed by Ms. Cliff and Mr. Hughes?
I'll move to approve. This is Keith
I might have one question on the actual language. And maybe it's not an issue, but in the current 420 or the proposed 425.110, where it has is not currently receiving and then it has not applied for the temporary assistance, is there an interest or do you believe a need to limit that to a time frame? My belief is that the intention for that is to have people who are currently applying, right, and not historically. I'm thinking of cases where someone had applied, years ago, that's been paid off or recaptured by the state, and now they want to stipulate. I would probably say that now and say that it's fine, but maybe has no current application for temporary assistance, maybe addresses that better.
I think the point is here, Margot Chapel, for the record, that they're not receiving it currently. So whether they've received it historically or whether they've applied for it currently, but they're not receiving it, I think that's what this is trying to get at.
I see what Mr. Sanford's saying, which is the application part, does the word current almost reads in the sentence like it doesn't apply to a current application, just it's never.
So the reason that Margot Chapel, for the record, that I'm clarifying that is that just because someone has applied for it doesn't mean they're going to get it.
Oh, okay. I see what you're saying.
I guess what I would say, my current, I guess my amendment would be everything would say the same except where it currently says and has not applied would say and has no current application.
Kathleen Baker, for the record. I would say that we could use Mr. Sanford's language, or we could just say there's no pending application. And I think that's relevant because whether they are granted their application or not, if they are in a financial position where they may need public assistance in the form of TANF, then this stipulation may not be appropriate to be entered into.
Okay. I would say from my perspective, just as a comment, it's the three of you that are discussing this and giving us comments right now, I would prefer it to read the way the three of you prefer it to read, because it definitely isn't an area that I see much of within my practice or can get great input on myself. And it will definitely impact the three of you as deputy DAs. So further comments?
I think actually that's a great point. This is Keith Pickard. Let me withdraw the motion and invite the DAs to circle up and propose language for the next meeting.
And I'm happy to propose the language as I guess put forward.
Okay, we have plenty of time for our next agenda. So if the three of you are okay with it, can you circle up as Senator Pickard stated and decide which way we want to word that language for us? I see head shaking.
Yes.
Okay. Thank you. I appreciate that. All right. So any further comments on this right now? Hearing none, the statement would be that the belief is the vote's easy. We're going to vote on this language. We just need to fine tune it, make sure it's exactly what you guys need. So with that, let's move on to public comment for agenda item number 11, please.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
All right, thank you very much. Let's move on to agenda item number 12, which is discuss and approve ideas for future agenda items. I also want us to discuss the next meeting date with the holidays. I want to be respectful on that. Do we have any suggestions for agenda items for the next agenda? I am going to hold over the AML ones in hopes that we receive something from them. And as I stated, at some point that may just drop off if we don't receive proposed language, or if any of you want to propose language on any of those agenda items, please do so we have something to discuss.
Madam Chair, Judge Hoskin, for the record, I didn't see it on the agenda, but Senator Pickard made this comment at the outset. It was my recollection that I was going to make some changes along with Judge Pickard. I'm sorry, with Senator Pickard. I was just talking to Judge Pickard, so that's my mistake. But we were gonna make some changes to 140. I didn't make those changes because in my notes I had that I was waiting for some suggestion from AAML on that regulation as well. So I didn't do that. And then when I got the minutes yesterday, I reviewed it and indicated that perhaps I could have done it without it. So I just didn't see it on the agenda. And if we can put that on the agenda for next time, I'll get with Senator Pickard and we'll get some language together for that.
Okay. And that was for 140, correct?
Correct. Yeah, the combination of 130 into 140, and then we had some concerns with regard to creating a list. So we were going to make some clarifications, and I'll get with Senator Pickard and we'll figure that out.
Okay, thank you. Additional agenda items? All right. Hearing none, let's discuss the calendar for the next meeting a little bit, which I have to pull up real quick on my computer. Because of course, next week is Thanksgiving, but a meeting 1 week out is not helpful for any of us, obviously. Is there a preference if we do perhaps December 3rd versus December 10th?
Kathleen Baker, for the record, I would actually prefer the 10th. I'm out of the office on the 3rd, but of course, whatever works for everyone else.
Jack Fleeman, I'm also out of town, out of the jurisdiction on the 3rd. So yeah, the date works better.
I am unavailable on the 10th, but I could have Kathy Kaplan attend as my proxy.
Okay.
The 10th works better for me, Madam Chair. Judge Hoskin.
Well, my input would be that's 3 weeks out, and I don't know that we'd have enough to talk about if I did one at 2 weeks out. So I would prefer the 3 weeks out. I also believe that's just soon enough before the Christmas holiday that maybe we can still get attendance at it. And hopefully we'll get some language from AAML then. So we will set the next meeting for December 10th, once again at 9 a.m. This time it was on Microsoft Teams because LCB could not facilitate this meeting for us today. So we did it through DWSS. There is a possibility it'll either be by Zoom with LCB or Teams again with DWSS. So sorry to keep you on your toes on that, but we make sure it's in the agenda each time and the instructions are there each time, and you'll receive them by email. Any additional comments for the greater good on that for this agenda item? Hearing none, we will move on to regular public comment, and those will be restricted to 2 minutes per person. If we could please take our concluding public comments.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you. Would anybody like to make a motion to adjourn?
No move.
You gotta hang out with me.
Second.
All right. Any further discussion? All in favor, state aye.
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 Opposed?
Thank you.
Abstains? All right. Thank you, everybody. We'll see you on December 10th at 9 a.m. Appreciate you all.
Thank you, everyone.
Thanks, everybody.